Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by LiveLaw, your one-step destination to all legal developments in the country. Starting with the update from the Supreme Court. Today was the 6th day of the Constitution Bench hearing the plea on same-sex marriage. Solicitor General Tushar Mehta, appearing for the state, today argued that arguments of right to choice and sexual orientation raised by the petitioners who are seeking legal recognition for marriages between non-binary, non-heterosexual or transgender persons may tomorrow be raised to defend incestuous relationships. Though the CJI D.Y. Chandrachud called the argument far-fetched, the Solicitor General was firm that tomorrow people could also challenge prohibition of polygamy on such grounds and incest and prohibited degrees. The discussion further continued on social benefits to the same-sex couples. The Supreme Court orally asked the Union government if it was willing to grant social welfare benefits to same-sex couples without conferring such relationships any legal recognition so as to ensure that they are not ostracized. The court suggested that recognition did not necessarily mean recognition by marriage. It could mean association, which entitles them to certain benefits. The bench asked the central government if there can be some measures giving financial security to same-sex couples by allowing them to have a joint bank account or name their partner as nominee in the insurance policy. The CJI has asked the government to make a statement to assist them on it in a non-adversarial manner. Justice Bhatt today observed that the government may not want to confer them any status, but it had to bring down the barriers. The arguments will now continue on the next hearing, that is on May 3rd. LiveLaw has been extensively covering all constitutional bench hearings, and on this issue also you can watch our other videos on our YouTube channel or visit livelaw.in. A new development came today from the Bombay High Court on the case filed by stand-up comedian Kunal Kamra against the 2023 amendment of IT rules. You already know Kunal Kamra is challenging the amendment that empowers the Ministry of Electronics and Information Technology to notify a fact-check unit to identify fake, false or misleading online content related to any business of the central government. The ministry in its affidavit had said that the intention here was to establish an evidence-based fact-checking system to deal with false or misleading information. Earlier this week, the Bombay High Court had held Kamra's plea to be maintainable. The new update today is that the central government informed the Bombay High Court that the fact-checking unit under the amended IT rules will not be notified till July 5th. Kamra further pleaded that the amended rule, even without the fact-checking unit notification, will hamper free speech. The division bench of Justice G.S. Patel and Justice Neela Gokhale said that there was no need to stay the rule, as without a fact-check unit being notified, the rule cannot operate. The court allowed Kamra to amend his petition to challenge the centre's competence to amend the rules, and the central government has been asked to file a complete response by June 6th. For more developments in the case, stay tuned. Another important news coming from the Delhi High Court, which today set aside the decision of Delhi University debarring PhD scholar and National Secretary of NSUI Lokesh Chugh from taking examination for a period of 1 year over his alleged involvement in screening of the recent BBC documentary on Prime Minister Narendra Modi and his alleged role in the 2002 Gujarat riots. Justice Purushendra Kumar Kaurav quashed the decision for violation of natural justice and restored Chugh's admission in the university. According to the petitioner, neither was he present at the protest site, nor did he participate in the screening in any manner. He was not given any opportunity to explain his conduct to the disciplinary committee, and the university had restored to a disproportionate action by debarring him for 1 year. Delhi University's response to the same was that the screening of the documentary inside the campus amounted to gross acts of indiscipline. They also said that rather than concentrating on his research, Chugh was instrumental in inciting other students to indulge in campus politics. The Delhi High Court today said that it will hear on merits a criminal contempt case filed against the editor of Tamil political weekly Tughlaq and RSS ideologue S. Gurumurthy for his 2018 tweet against Justice S. Muralidhar, presently the Chief Justice of Orissa High Court. A division bench of Justice Siddharth Mridul and Justice Talwant Singh listed for hearing on July 6th the plea moved by Delhi High Court Bar Association seeking criminal contempt against Gurumurthy. Gurumurthy had tweeted asking a question whether Justice Muralidhar was a junior of senior advocate P. Chidambaram. The tweet was made after an interim protection was granted to Karti Chidambaram by a division bench headed by Justice Muralidhar in the INX media case. Karti Chidambaram is the son of senior advocate P. Chidambaram. Post this, Justice Muralidhar had categorically clarified that he had no relationship of any kind with Mr. P. Chidambaram and that he had never worked as his junior. I would like to remind you here that last month the court discharged filmmaker Vivek Agnihotri in a suo motu criminal contempt case related to remarks made against Justice S. Muralidhar on Twitter in 2018. This case also names Gurumurthy as an alleged contemner. And now an important update from the Calcutta High Court regarding the incidents of violence last month during the Ram Navami celebrations. The Calcutta High Court today transferred the probe in the matter to the National Investigation Agency NIA. The bench of Acting Chief Justice T.S. Sivanganam and Justice Hirannamay Bhattacharya directed the state police to hand over the FIRs, papers of the case, seized materials, CCTV footage, etc. to the NIA within a period of 2 weeks. As you already know, West Bengal leader of opposition and BJP MLA Suvendu Adhikari had filed a public interest litigation plea seeking an NIA probe in the matter. The Calcutta High Court bench noted that swords, bottles, broken glasses and acid were used in the violence. The internet was restricted, which shows that it was large-scale violence. The report's prima facie suggested that the violence was pre-planned and therefore a central probe agency would be better placed to probe the matter. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us.